And
Okay,
we
well, we're going live.
we
Hello,
are
everybody. Jim is being mean.
good morning and welcome to the shit show. I'm on my phone for the first few minutes, just to get us through until the actual court starts. I still have no power and no ETA, as 29,000 people are without power in the area.
Nice.
Yeah.
So you're stuck with me. I think
Yep.
I will try.
It is.
I think I will try our opening and see how that goes.
Okay.
Well, that was exciting.
That was exciting, but it killed 2 minutes. So there you go.
I have something else, so we can move on to something else while we're waiting.
What else do you have for them?
I have a drunk girl that I sent you. That I hopefully I can.
Oh,
share
you're
this
gonna play
in-
some drunk girl. Okay.
and hopefully I can share my screen here and this will work. Let's try it.
Yeah, it better, or else we won't have cover to Karen Reed.
She's actually not really a drunk girl so much as I think she's high, but a good example of what not to do during a
Damn,
traffic.
people are like getting on the fucking brakes, man. Jesus. Come on. Even the car behind me about ran into me. Hello, driver. This stop's audio and video recorded. Okay, you've been stopped for license plate. I can't understand what your plate's reading there.
All right, so I just drove from Georgia. So I've been trying to get my car registered and insured, but I'm going to my mom's house. She's supposed to be doing it.
Okay, all right.
Because I couldn't register and insure it because the paper was signed wrong. But I'm going. She got my
So
paper.
that tag's expired, right? That's on the back of the car?
I just found that out just yesterday.
Okay, all right. You have a driver's license?
I can't
don't have it
register
on me, but I
it,
know
so
my
I'll
driver's
just
license.
continue to
What do you
drive.
have your license on you?
I forgot it. All my stuff is in my mom's car.
Yes, you better.
Okay.
You want me to call her?
No, what I want you to do is write your information down here for me. I need your Florida driver's license information. Do you have a Florida driver's license?
From Rhode Island.
Have you ever had a Florida driver's license?
No, I just moved down here.
Give me your name, date of birth, and your current address. Hey, go ahead and call it out for me, would you?
Yeah.
I don't know if you'll be able to read that tag or not.
Tango 15, 1050.
I just been going through a lot.
I understand.
I'm moving, yeah, my family, and when I moved down here, my family's moving also.
Okay.
So the fact that they move in, the fact that the fact that I moved down here and we moving up, and then the fact that I moved down here, I called them when they're moving too.
Okay. I understand completely, dude. Yep.
And I'm still like, I'm sorry.
You're fine.
Sorry. Do you want my license number, please?
Your license number? Yes, ma'am. That would be very helpful.
Like that.
All right. How old are you? You look very young.
Yeah, thank you. It's the Asian in me.
So, it's a Rhode Island, is that right?
Yes. So I'm just,
Sydney, how do you say your last name?
I'm just gonna, yeah, my mom said that she was helping me. Like, we tried to register it yesterday at the
Yeah.
DMV, but she said that, they said that the person that sold me the car didn't sign in the right area, so we had to fix it. And I forgot the paperwork in my car.
We'll figure it all out, but you got to give me a minute, okay?
Right.
Do you have any paperwork for this car inside this car?
No, it's in my mobile car.
No paperwork for the license plate?
No, can I get the picture from her? It's in her car because I tried to register my car yesterday.
No, that's okay. What I'm going to have you do is set your phone down and come on out over here and stand with the officer on the curb, okay? While I figure out this car, okay? You just leave your phone in the car.
Can I call my mom?
No, ma'am. There's no reason to call your mom.
Now I realize this is.
If we need a minute, we'll get the phone for you. Just stay with these officers right here. Just come to that window. I'm live and I'm going to stay
Olive
live.
was trying to kill me.
She looks like she's got impairment.
Oh, nice.
You can smell the burnt cannabis in the car.
Yeah, there's a bunch of.
So
Yes,
she's
that's
actively
why
driving
the
smoking.
video was
there's some
on.
in there?
It's old. Like
Okay, yeah, that's fine. She's been active smoker with us now, right before she got in the car, but she's slurred speech. She got several things going.
Okay.
What's she balling now?
Yep.
Hey, Sydney, can you stand up for me? Stand up so we can talk, okay?
Please.
Let's step on over here in the shade. What are you upset about?
My cousin. So my cousin had passed away, and I just need her. That's why I moved back, because I don't got no one. I just want my mom.
Why does that have to? What, okay, well, your mom's not in your car when you were driving, right? So there's not a problem. You can't ask.
I'm just like, I'm not from here. I don't like being alone.
And I'm going to work. If you're worried about that license plate, we're going to figure that out. That's not going to be a huge deal. Let me tell you why I have officers here, okay?
Yeah.
In just a few seconds, I'm going to do a roadside evaluation to see if you've operated a vehicle while in a state of impairment off of the cannabis that you've been smoking. You can't operate a vehicle in Florida after you've consumed, ingested, or whatever controlled substances.
When I leave, like how I just walked out.
So we'll talk about all that.
I just left my mom, like literally, I just left her.
And
And like in the parking lot.
I just left her, but I was
She told
driving
me to go
to
drive
it.
the car and drop it off, and that's it.
Okay, and we'll figure that out.
She said she was gonna meet me. I just want my mom, please.
Yeah. Okay. Well, we got to do this first. Okay. Let's step away from this tree so I don't have this in my face. Here we go. Turn around and face me.
You're an adult.
You're 21 years old. You're an adult. You know, there's some things that you're going to have to figure out on your own in your life, and this is one of them. It looks like. Okay. Just because you and I are talking doesn't mean you're in any trouble at all. All right. It just means you and I are going to have a conversation. I'm going to evaluate you to see. You've obviously been smoking some marijuana. Okay.
Yeah, at the house.
So, do you have a medical marijuana
And
card?
just
No,
wait.
I smoked at the house
It gets
with my,
worse.
with my brother.
So,
My mom was there.
when you smoke or when you drink alcohol or anything that
My
is
mom was
intoxicating,
there.
okay, you can't operate the vehicle.
No,
When that
yeah, but I was
intoxication
parked
gets
when
to-
I smoked.
Huh?
I was parked when I smoked.
But immediately
Oh,
after
like
you're
I
driving.
can't. Yeah, I can't.
It's like
so
drinking
I'm not.
6 beers. It's like drinking 6 beers, waiting 20 minutes and getting your car and driving. You didn't drink and drive at the same time, but you did after you had the intoxicating substance, okay?
Yeah, I'm sorry.
So you and I are going to have a little evaluation on here. Doesn't mean you're in any trouble. Part of that evaluation is I need to read to you what's called your Miranda warning. It doesn't mean you're going to jail. Have you ever heard your Miranda rights? You have the right to remain silent type thing? You ever heard that? It doesn't mean you're going to jail when you hear this. It means I want to ask you a specific question when I'm done, okay? If you'll listen closely to me, you have the right to remain silent. Okay, you listening? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you. You can decide at any time to exercise these rights, not answer any questions or make any statements. Do you understand the rights? I read them to you.
Yes.
And having that in mind, are you willing to talk to me now?
Yes.
Okay. All right. It's going to be real simple. I'm not going to trick you. Okay. I'm going to ask you some questions. I expect an honest response. Don't lie to me. I would rather you not answer than to lie, okay? So you already told me that you smoked a little bit of marijuana before you drove. About how long ago was that?
Probably like 30 minutes ago.
Okay. And you do not have a medical marijuana card?
No.
About how much marijuana do you have in the joint, we'll call it, that you smoke?
I only had a gram in the joint that I smoked.
1 gram.
Yeah.
Okay. About an hour ago, 1 gram.
Yeah, 30 minutes, 1 gram.
Are you a diabetic?
No. But I am anemic.
Pardon me?
I'm only an anemic.
Okay. You don't have epileptic seizures? Do you see a doctor weekly or monthly?
No.
Okay.
I won't.
Are you prescribed any medications?
No.
Just what?
No, I'm not.
No? Okay.
The last thing I took was antibiotics, but I don't take them anymore.
Okay, that was a while ago. Okay. And then you're, based on what you're telling me, then you have pretty good health. Is that right?
Yeah, I used to pass out a lot, but I don't pass out no more.
Was that from anemia, being anemic?
Yes.
Okay. I noticed that you've walked without a cane, you've walked without crutches, you don't have a handicap placard in your car. So there, you don't have any physical defects that keep you from simply walking, turning, or doing motion. Is that right?
Yeah.
Okay.
I do have, like, my tailbone's broken. I was supposed to
your
go
back.
get checked
Your
out.
tailbone?
Yeah, and I was supposed to go get checked out, but I never went. And I was like,
How do you know the tailbone's broken?
I went to the
she used to
hospital.
pass out a lot, but
So,
And they were, how long ago was
anymore.
that?
they told me I had chronic pain. It was in Atlanta, like, this year. And
So it's been a
probably
while.
March. Yeah.
Is that why you smoke marijuana, for the chronic pain?
Yeah, it helps me, like, sleep and stuff. Like, it helps me get through the night.
If you smoke it for chronic pain, why don't you go get a medical marijuana card?
I just haven't had a chance to go back up north in Rhode Island from where I'm from.
Well, you can get one here. Okay.
I just came back from Georgia.
Yeah, if you're
So-
living here, you can get one.
Yeah.
Yeah.
I'm gonna.
That's something maybe you can work on later, right?
Yeah.
Okay. Right now, are you feeling sick?
No.
You feel injured right now?
No.
Okay. I know what you're telling me about your tailbone. I believe you.
Yeah.
But it doesn't prohibit you from doing simple movements. You were
Yeah.
sitting on it without any special
Yeah, I know,
cushion,
I'm sorry.
or you have no.
No,
pass.
I have a donut, but I just don't use it.
But it's not in
Yeah.
that car right now.
I bought it from a pharmacy, but it's not
Yeah.
prescribed.
But you're not using it right now.
No.
So it's not something that you're dependent on. It's something maybe that gives you a little more comfort, but it's not
Yeah,
something you're dependent.
Yes.
Okay. All right. And again, I've seen you walk over here. I've seen you even sit down on the ground and get up on your own.
Yeah.
So there's no problem there. Okay.
Yeah, well, yeah, I probably am. Jim. Oh, Jim. Well, apparently we have Jim, but we can't hear Jim.
Just take off your glasses for me.
I can't.
Yeah, just take them off. Okay. Take them all the way up. Just put them in your pocket. You're not going to have to read anything. All right. See the tip of this ink pen?
Yeah.
Follow the tip of that ink pen with your eyes. All right. Do not move your head. Do you understand?
Mm-hmm.
Here we go. Doing fine. Doing fine. Open up the eyes. Open them up. There we go. Don't move the head. Open up the eyes. Don't move the head. Open up the eyes for me. I'm just going to show him something.
Are we done yet?
You're doing fine. You're doing fine. Okay. Let's open your eyes up. Open your eyes. There you go. Follow the pen straight up. Do not move your head. This time I'm going to go around your head. I'll bring the ink pen towards your nose, but I will not touch you. Okay? Understand? All right. Open up your eyes. I'm not going to touch you with the pen. See that? Your eyes aren't. Yeah. Okay. Just fine. What I was showing him was your eyes are showing things. People that smoke cannabis regularly, there's certain things their eyes do that a person that doesn't smoke cannabis their eyes won't do. So, do you smoke probably about a gram a day then?
Yeah, I don't smoke a lot. I don't. I really don't.
How many times a week do you think you smoke?
Probably like 3 or 4 times.
3, 4 times, and
When I like feel like I want to or need it for like when I need to go to sleep and I have trouble sleeping.
Okay, all right. So about 3 or 4 times a week at a gram apiece. Okay. No other medications?
No. Am I getting a ticket?
You what?
Am I getting?
We haven't got anywhere near that yet. Okay, we're still doing this interview here. This is going to take a couple more minutes, and then we'll be done. We'll decide what's going to have to happen there. All right. Where's the marijuana at in your vehicle right now?
And I don't have none.
Don't go get it, but you what? Would you
I have like a roach.
Okay.
It's in the middle.
In the console?
No, in the cup holder.
Okay, in the middle, there's a burnt roach.
Yeah.
Which means that you were smoking marijuana?
No, that was I told you I was just at my house.
Whose burnt marijuana is that one?
That was what we were smoking.
So you smoked it and then brought it with you?
No, we parked and smoked, and then I just
in the car.
Yeah, and then my brother got out and I just left.
Okay, so you smoked it when you're setting
it.
up.
I like how she keeps going.
Is that in front of your house?
That somehow
What
matters.
is your house address?
I'm staying at my mom's house.
Okay, so you sat there with your brother and smoked in front of the house in the car.
Yeah.
Okay, about an hour ago. Is there any marijuana in your coat right now?
No, you can check it. It's
Okay.
just empty.
Yeah, we might do that in a minute. I'm not too concerned about that. We have a couple more things we're going to do. These officers are going to stand with you while I do some things. I'll come back and we'll keep moving. Okay. All right.
My little brother, I need to call my mom to get him. Can I just call him?
So
Not yet, but I mean,
yeah, give me a moment.
I'm allowed to use my phone. They said.
Who told you that?
That's what the law is, right? They
No,
said
not at all. That's
record and stuff.
nowhere near the law. No.
But I need to call my brother. Is gonna be stuck there.
How old's your brother?
He's like 14, 15.
Okay, where's he stuck at? At school, right up here. That's where he's going to get him.
On the way there, yeah.
Yeah, he's at that age. He'll be fine waiting on you. He has a phone of his own. Is that right? So he can give her a call if you don't show up. I'll be right back.
And it's about to get really bad.
Are you okay? Are you okay to stay with us? Okay. We'll talk about what we're getting ready to do. It's real simple.
I just don't got a bra on. That's why I have
the coat. That's fine. I'm running too, but I can't do this, right? You have to do it?
Yeah.
Okay, all right. So I was going to say how I'd like to
We're just going to walk through this to see it.
Yeah, okay.
And I'll talk about what our plans are tomorrow after this. Actually, hey, if you want to do the HGN all over, if you want to start from there, you can go.
Yeah, just do the FSTs.
Do the what?
Do the whole FSTs.
Yeah, if you want to start the HGN all over again, you heard the interview. You don't have to do that over.
Yeah.
You can do the HGN and move right into the other two if you want. If you don't, I'll do it. I don't care.
Yeah, let me try it.
Yeah, that's sure no problem.
The only problem I have
we're
with
just
him about
yeah.
lying
I
is
know
he
I
didn't
could,
have it
but
on camera. But he can't
I'm not
go
too worried
viral.
about that.
He doesn't put it on camera. He can film me.
Right, so
And he
the
won't
tip of this
listen to
pen,
me.
All right, what color is that?
She's a heavy cannabis smoker.
Go ahead and focus on here.
I got a funny story for you later.
Pardon me?
So I have a funny story for you.
Yeah, don't tell me on camera. No. You're always good for a story.
Doesn't really matter, but it might be helpful to just keep them
She
on.
wants to sit
It's not
down.
really that sunny right now.
It's not my sunglasses. My prescription.
Your prescription? Okay, you can keep them on that. Okay, if you want to come over here, we're gonna start the second test.
I have to walk on that line.
Yeah.
Hey, the one thing I would offer to do is if she wants to remove the shoes and do it in her socks, she can.
Yeah.
It's up to you.
Left foot in the center of the line. Hang on, really close. Finish the instructions. You're gonna go put your right foot, right heel, your left foot's toes, like this, in front of the line. Your arms are gonna be down at your sides. Yep, just like that. You're gonna watch where you go. Don't move until I tell you to start the test, okay? Do you understand? Do you understand? Okay. When I tell you to begin, you're gonna make 9 heel to toe steps. Understand? Okay, you can begin the test. test, just like I demonstrated. Just like I demonstrated.
1, 2, 3, 4, 5, 6, 7, 8.
Okay, so you can relax. It's gonna be the one-legged stand. You understand? Yeah. Okay, so come over here.
9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35,
Until I tell you to stop. It's in.
41, 42, 43, 44, 45, 46, 47, 48.
You can stop. So, see me right now. All right, we're gonna place you under arrest for suspected DUI. Okay? Yep, just right now. All right, we'll explain more what's going on.
Yeah, you're under arrest for operating a vehicle
facing that
intoxicated, man. That's the
Just relax.
intoxicant we believe to be cannabis.
Can you call my mom?
We will take care of that.
Listen, I'm gonna double lock these so they don't tighten up on you. All right?
Can you call my mom?
Yep, we will.
Call my mom.
Take a 15, we're 10, 15.
Call my mom.
We will. We'll take care of it.
Call my mom.
You're fine. You're 21. You're an adult.
Very skinny.
Please call my mom.
We'll bring the phone with you. You'll get that opportunity, okay?
Please call my mom. Mom!
Yeah, I'm not tightening this one. Just
Please call my mom.
Sydney, relax. Relax.
Please call my mommy. Please.
Okay, you'll have the opportunity to do that later, okay?
When I'm in the cell, when I can't get out.
Yep, you'll get out.
Myself.
Yeah, very skinny. That's gonna have to
The
be
last one.
Miss Parsons, there's your puffy jacket.
Okay. All right, Sydney, we're gonna go
Would
over
you
here.
search her for us? Yeah.
And that's here, right here.
Have anything
We're gonna stay live for the vehicle search, and we'll be off.
I have my cousin's gun on me.
Pardon me?
I have my cousin's gun on me.
Stop. Don't reach.
Don't get a gun, yep.
Wow,
Let go of it! Let go of it! Let go!
Let go.
Let's go.
Let go of the gun!
I got it.
I'm sorry. Let go. Just take it out, please. I'm sorry. I'm scared. This sounds traumatized.
We're good.
I mean, I can't breathe.
Well, you don't grab it if you fire it or you shot
I mean,
somebody.
I'm sorry. I was gonna hand it to you. I'm sorry, sir. This is my cousin's gun.
Okay,
It's not
all right,
his.
we'll figure it out.
This is my ex-boyfriend's cousin. Can you call my mom?
Several things here.
You'll do that later. All right, let's
Tell
finish
them
the
you
search.
have a gun on you, and
Get her a
also
position
I
we
didn't
can.
say pat her down before that.
Just make sure nothing else.
My life is over. I didn't do nothing, I promise. I go to the gun range. I'm clean. You can search me, I promise, yo. I promise, yo, my dead cousin. I don't got nothing. I go to the gun range with my brother and my cousin. Oh, man. I might be pregnant too. I don't know.
All right, is she searched?
Yeah,
Let's bring her up. Go ahead and stand up.
Come on.
stand
Here we go.
Okay.
Stand up. Stand up. Stand up. Yeah. Let's finish the search and then.
Y'all got me. It's cool.
All right.
I don't got nothing. I promise I'm clean. I didn't shoot nobody.
All right, well, we
I
got to
go the
continue
gun
what we're
range.
doing. All right, we're
You
good.
can see the paper behind. I go to the gun range. I promise you. I
Okay,
do.
I understand. You got a gun permit on you?
No, but I go to the gun range. They
Okay,
allow
that's a
to.
concealed carry, but we can talk about that later.
I didn't know,
You're
I'm
comfortable with our
sorry.
search? All right.
They allow us to bring guns to the gun range, though.
Okay. It would have been nice if you'd have told us about it from the beginning.
You got a brown paper bag?
I probably don't, to be honest with you.
I got one in my trunk.
Yeah, go get it.
In my file folder, and like the second pocket, I got brown paper bag. Can you grab this out, please?
I wasn't worried about the gun until her hands got
That's
on
what I
it.
said.
Huh?
Yeah,
I wasn't worried about the gun until her hands got on it, and then she wouldn't release
that's
it.
the thing.
But she's going to pull the trigger, you know. All right.
Was there
It's in
one?
the trunk.
Was there one in?
He's going
Was there
to...
one in there? There wasn't one in the chamber.
Good job. What's it with you and guns, man? No shit. You're fine. Don't bang your head. That's just being silly. It's not going to get you anywhere. Just relax.
I can't buy.
Huh?
I can't buy.
So you got gloves? Yep. Let's do a search intent to arrest.
Hey.
Yep. You'll do the patch settle.
Hello.
We'll knock this out real
How
quick.
did you grab one or two?
Okay, we're waiting for the trial to get started. So we're watching. It's actually a high girl, not really drunk, who goes through the test and then is being arrested as she's being handcuffed. Then informs them, "I have a gun."
Oh.
And all the while crying for her mom.
Okay then.
It's kind of fun.
Where's
We'll
Jim?
finish it up here. It's almost done. He's been in and out. We only have a few seconds left on this, so we'll finish this out.
All right.
Yeah. Are you live on your camera? All right. So if you find drugs, guns, whatever, get it good on camera first, and then we can recover it.
Thank you, Jerry, for making this happen. That was kind of fun.
Mm-hmm.
Yeah. So how are you, Hank?
Recovering.
Recovery? You not been feeling well?
Had a round with COVID.
Oh, I did not know that. So you're okay though.
Yeah, just fatigued as hell, and my taste buds are out of whack.
So okay, so then I get all the yummy brisket. I don't need to send you any because you can't taste it for shit.
Yeah, I'm not wasting my time on on preparing foods that are very tasty. Pretty much sticking to the bland foods.
I don't blame you. I don't blame you. They apparently moved up. I'm not sure exactly. I keep checking Law and Crime. They have not gone yet. So as soon as they do, we will do that. Jim's power is out.
Raccoon Army.
Yeah. Apparently there's like 24,000 people without power.
Wow.
In his neighborhood. So
big neighborhood.
Yeah. I'm guessing the surrounding area. Yep. Thank you, Becca. Yes, they are scheduled at 2. I know that, which is 1 p.m. where it counts. So we should be going live pretty soon. So,
well, isn't it 2 p.m. there now anyway?
Yes, it is. But they haven't started yet. So one of the other networks had it scheduled for later, like at 2:15 on the East Coast, 1:15 where it counts. You make a 12:15 Mountain and 11:15 on the West Coast. And you're watching WFYC 99.9 on YouTube.
Alrighty then.
So we'd like to thank you for tuning into our impromptu coverage. I apologize, you're stuck with me as your host. That's how it is. And I'm boring Hank to tears.
No, it's not you.
Well, you guys are saying it started. I have long time on another tab. It's not showing it started. So if it started on somewhere else. Part TV. Okay, well, let's try Part TV. Give me a second. We is professional.
Uh-huh.
Okay. There we go.
What's today's hearing for anyway?
I believe it's one of the pre-trials, so they're going to go over and perhaps maybe because I think they already set a trial date. But
January 25th, if I'm remembering correctly.
Judge, there are two central issues. There's not one for amplification, there's one for court.
I just want to make sure I hear.
At a day like this, I'll keep my voice.
Okay.
Thank you. There were two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe.
Well, give this attorney credit. He's already less of a dick than Jackson.
That's a very low bar.
I know.
Described as an extraordinary jury reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2 and lesser included manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting, second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not in an impasse, evidence evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial. Evidence not known to Mr. Lally or the prosecution or the defense. That in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to two constructions. One, that their impasse covered all three counts, and therefore would lead reluctantly to a mistrial declaration. Or two, that the impasse was on one count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court, neither did counsel. But the issue now, and again, it's in the context of double jeopardy, it was such an historic and important clause. It was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty.
So the first jury couldn't find him guilty, and now it's all of a sudden the prosecution forced a mistrial.
When we now know that jurors are declaring in court that they believe they reached a verdict of not guilty. What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over.
This attorney looks like he might have known the founding fathers personally.
And I contend, Judge, that we can't just accept a fiction.
I remember when Ben and I were in the ale house talking about this.
4 jurors are saying to the full counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision making. The second one, the manifest necessity issue, has got a lot more SJC.
Change out his glasses for wireframe, and you might have Ben Franklin.
I know. I was just
walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here, what we know is that 4 jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't denounce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory. And that makes them more trustworthy. They corroborate each other. And I contend that the voicemail left on Mr. Lally's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil her the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity. Every juror seems to want it. And that's understandable given the
Thank you, Turtle Boy.
public attention on this case.
Yeah.
And the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Malley. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people other than people that go into military service, have opportunities to serve their community like these jurors do. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that were memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I try to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. They are making that point.
I feel like it's not really a strong argument if you're going with the dissent.
Procedures important to inform, sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay
Thank you, Verbo.
Exactly what I want. But in this,
For those wondering, with the audio, it is low. It seems to be a court issue.
Prosecuting somebody, the same prosecutor for the same offense, where there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, I remember it because it was the tail end of the Warren Court.
Because he was there.
And it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Matt v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleading, said, and it's important, That double
I don't
jeopardy
blame
was
you, Matt
designed
G.
to protect
Please do
individuals from
come back, and
matters
don't
of the
forget to
hazards of
like,
trial
share, and
evidence.
subscribe if you haven't already.
That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these two jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in a case dealing with a lawyer's allegation that there had been a racial statement. It's called the McCallum case, 485-90. It said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during that the jurors accessed the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can test that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't
Maybe
it
independent journalist
just the same
had some effect on him.
You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, sorry, we ask, authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate. Or Alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed on counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence it was not, to establish a procedure consistent with McCollum, consistent with Sanayev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, where there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those two charges not be re-prosecuted. So let me switch from the acquittal and its implications to manifest necessity. In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court, that look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. If here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, or we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 instructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, and is one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to
Lisa,
allow the trial to continue with a jury of 5.
The gentleman speaking is her new appellate lawyer. He is from Massachusetts, and his name escapes me right at the moment. But he replaced Jackson.
Defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read,
can we just call him Wish List Ben Franklin?
because there was a viable option.
We can call him Wish List Ben Franklin.
Okay.
The court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant make them go to trial a second time in the face of double jeopardy's manifest necessity requirement? Or are we going to put the burden on the prosecutor to have advised us?
I will say, so far, he is making far better arguments.
This case is similar, Judge. Because
as far as lawyering goes, he's doing a fine job of lawyering.
Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on
and as far as lawyers and Ms. Reed go,
but this is different.
Yeah, she was messing around with Jackson. I don't know if she still is.
Rule
And
27B
to be determined if she's messing around with this lawyer. I guess we'll find out what happens. You are speculation on my part.
Says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them two principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard. And I'll address that second. And, quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those two guiding principles were met by the evidence in the report on July 1, where we have the chronology, if Your Honor, taking argument from counsel regarding the warning note, and the prosecutor didn't want a 2E instruction. Defense counsel did. Your Honor elected to give a 2E instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate to succeed in reversing a judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, in Nicole, the Appeals Court in a case, Commonwealth versus Oregon, that we've cited, in light of the importance to the defendant's right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor. So again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised you, Judge. So this was a case that really comes down to whether or not.
So the defense didn't object. The judge apparently didn't know the rule, but the Commonwealth should.
The criteria, a full
Got
opportunity for the defense to be heard before the court read the final note, issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial.
Hey, Erica, thanks for stopping by.
To Your Honor,
Hope
this
you're well.
is not easy. This was a long trial. Prosecutors had strong evidence that the jury was in fact deadlocked and in fact at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, since rather than double jeopardy.
Thank you, Burbo.
They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits or cut right to it, that the attorney declarations satisfy our burden of production. If this Reed was acquitted, bring the jurors and judge here for me. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
You want me here?
Wherever you.
The Commonwealth would ask, request that defendants motion to dismiss be denied, as it was not
Oh, Drake. Even worse audio.
An opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel was asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, when 1 did not return a verdict, 2, counsel had adequate and ample opportunity to object to the declaration of mistrial, and 3, that the mistrial was declared out of clear manifest necessity, which the court, case law, has repeatedly stated is a typical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries.
Okay.
There's quite a twisting of logic into sort of.
That was not me.
In order to have the circumstances of this case fit into the precedent, there's a reason for that, because there is clear precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. As the court is well aware, that's a case in which, following jury deliberations and the defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation room in which the verdict slip was marked not guilty. That case stands for the proposition that where those slips were in contradiction with the jurors report to the judge in open court, that they were deadlocked, that does not guilty finding on the verdict slip does not contravene or overrule the verdict as it is applied in open court. Quoting from that case, and I think it's directly applicable to what's been provided to the court so far. It states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were controlled, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, as a contravention to that case law, in juvenile, in Bluefield, in Roth, in Gray, in all of the cases over the decades and the centuries dealing with this. Bluefield itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carney as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave. That stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to record that unanimous verdict. And there was no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was doing, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary group, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted to them, which Commonwealth would submit were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertains to the charges. In the final note that was submitted to the court, they refer to the charges in the plurality, twice within that note, as it pertains to exactly what they were studying. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel has to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting a mistrial. That's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, or reported to be at an impasse. Counsel, and these are Mr. Yannetti's own words, on both occasions, indicated that from them, or argued for Arturo Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for this trial at those particular points, at least leading down. Now, as far, and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states. Counsel's request for Arturo Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to confer on possible alternatives to mistrial. Ferrer versus Ferreira is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument, any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest. And I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of the manifest necessity is a deadlock or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Yannetti during his arguments for the Arturo Rodriguez recognized the same. The dangers of coercion when it comes to deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Buford decision from the United States Supreme Court and the Supreme Judicial Court of this Commonwealth, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those, how the jury stands, or whether or not they have a vote, or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when they're talking about charges with
You're still awake, Hank? I don't know. I'm not.
Multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty equal guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe as far as not allowing for the court to inquire into those types of scenarios. So, yes, the defendant's position is the court should uphold or inquire only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive holdings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, and very deliberately, as far as the language that was used, declared themselves to be at an impasse on 2 separate occasions, the last of which included language to the effect that any further deliberations would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mistrial. And it is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The 2 areas that counsel is talking about and sort of asking for an extension of creation of new law, again, sort of special or deferential treatment to this case or this defendant. The 2 areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance in an instance in which there is some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your own, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process for the jurors is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. So case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror or the juror calls you, it still does not allow the counsel or the court to then have these conversations with these jurors that delves into their deliberative processes or their deliberations. The specific type of coercion that is feared by the courts when it comes into this, and I'll sort of condense quote from Commonwealth versus Law. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlock. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, is prohibited by the law, is prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth nor anyone wants to try someone who has been acquitted by a jury or retry them for the same thing. That's not what happened. There was no verdict returned by the jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of mistrial. And the court did absolutely nothing in finding manifest necessity as the only alternative that could have been employed in that particular case. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
May I reply, please? Thank you. There were two cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile, it's actually juvenile versus Commonwealth at 392 Mass 52, 1984. Says the judge was under no duty to inquire.
There you go, Verbo. She is giving him the eye.
On each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, "We deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. 2 separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser included. That's the principle of Commonwealth v. Roth, the other case that Mr. Lally referred to. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includeds. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Buford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they were. They needed to decide all of the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached 2 decisions, 2 general verdicts, but we're in an impasse on a 3rd one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Sanaif case, where they've had, just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lally's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted the mistrial, he could have asked for a mistrial then. Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui, I think it's a 19th century federal case, is that you have hope when you're asking for the Tui instruction. My experience, usually the prosecutor who's confident in the jury that wants the Tui instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a Tui instruction, reflecting that he wanted further deliberations. So it's no answer, and the Ray case does not say that when you ask for a Tui instruction, you are really asking for something more than a Tui instruction. Tui means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those 2 colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence a second 12 when she's already convinced the first 12. Thank you, Judge.
Thank you. Any responses to that? All right, thank you very much. I'll take this under advisement.
Thanks, Judge. Judge, when I hand the Nicole case to your Honor.
Sure, thank you.
What will rise? Alrighty then. Okay. Well, that was
Happy,
interesting.
happy, joy.
Yes. Happy, joy. Okay, so the defense wants at least 2 counts tossed out against retry. I think they want to doesn't think they should be retried at all.
Yeah.
Interesting. So we will see. We'll have to wait until the judge reaches a decision and see what happens. My feeling is that she'll probably deny the motion, but
I'm thinking so.
so no official verdict. Well, that was a fun stream. Thanks everybody for coming out. We hope you enjoyed it. When we have more news, of course, Jim will share it. I have to find our closing thing here because I are a professional.
Right. Right.
I think I saw it. Hold on. There we go. Okay.
I knew you wanted to play it just so you could talk over it.